Ayubowan, Vanakkam, and welcome. You are tuned on to the Bar Association webinar series, and this is the 19th episode. Today, we are discussing aspects of company law and corporate governance. If you are a company lawyer or a corporate lawyer, you will appreciate that the company is one of the greatest inventions of mankind. Apart from people who can sue and be sued and who have rights, incorporated entities can do so too. As you know, this BASL webinar series is a part of continuing professional development, and you are tuned on to a collection of experts and mavericks who have logged on from wherever they are to share their expert opinion. I am delighted as much as I am inspired and honored to introduce the following panel to you, who has not only embraced technology, but also been willing to break the mold of the norm and come forward, and you will see something that you have never seen before, and that is one of our Justice Salim, President's Counsel, coming to you live from what looks like a nice coastal area. But don't worry, it is embracing technology. This is your panel for this evening. Justice Salim, President's Counsel, former Judge of the Supreme Court, President of the Court of Appeal, and former Additional Solicitor General. We also have with us Mr. Avindra Rodrigo, President's Counsel and Barrister, with 25 years of experience in commercial and corporate litigation. We have with us also Mr. Sadi Wadood, Attorney at Law, Director of Listed and Private Companies, an author of a book we all have in our libraries, Ms. Dilshani Wijegunawardena, Attorney at Law, Vijayawardena, Attorney at Law, LLM from the University of Cambridge, Attorney at Law, and former Commissioner of the Securities and Exchange Commission. Our moderator for this evening, to whom you will direct your questions. Some of you have already directed your questions, but if you have any other questions, you are welcome to direct it our way, and we will hand it over to this gentleman, and that is none other than Nilshanta Sirimana, Attorney at Law, LLM London, with over 20 years of active practice in the area of commercial law and public law. And I believe they have all been former lecturers, and you have seen or heard from them before in some form. Enjoy the session. These are your panel of experts. Moderator, over to you, sir.
Thank you, Tanya, for the introductions. Very warm welcome to all those watching the Bar Association's 19th webinar on aspects of company law and corporate governance. Now, company law and corporate governance are relatively vast and constantly developing areas of law. The Companies Act itself is a very large piece of legislation that runs into almost 534 sections. Therefore, we propose to address in today's segment certain important aspects of the Companies Act of 2007 and corporate governance, which we feel will be useful to our viewers. Now, after we conclude the discussions with our distinguished panel of members, we will be entertaining questions from our viewers, which I will then put to the expert panel for answers. The question and answer session will commence at approximately 6:30 p.m. and last approximately half an hour. Firstly, let us deal with actions relating to oppression and mismanagement and the remedies relating to those actions. Mr. Rodrigo, as a seasoned litigator and very experienced counsel in the field of commercial and corporate law, and as a counsel who has appeared in many minority shareholder protection court actions in Sri Lanka under the present Companies Act as well as the previous Companies Act. Can you tell us the circumstances in which shareholders can avail themselves of the oppression and mismanagement remedies under sections 224 and 225 of the Companies Act of 2007?
Thank you. I think one day I should check if everyone can see and hear me. Nishant, thank you for...
Yes, we can hear you, Mr. Rodrigo. Go ahead.
Thank you, first of all, for the introduction, and thanks to you and Tanya for organizing all of this. And may I say that it is an honor and pleasure for me to be on this panel with Justice Sani Masuf, whom we all respect and have a great deal of affection for, as well as Dilshani, whom I once was in chambers with Mr. Kanagiswaran. She's a good deal more learned than she or I was at that time now. And also my friend, Mr. Wadud, whom I can't see for some reason, but I presume he's also there. Yes, so let's get into the questions. And I think just a little bit of introduction before we look at oppression and mismanagement and its specific remedies. And as Nishant, Mr. Simana said, and Tanya also, we need to look at the structure of a corporate first and why people once upon a time, and this is an old institution or old structure, decided to get together to do a common venture, cooperative, and that is how the word a company has come up. And you get together with a bunch of other people for a common venture. And before oppression and mismanagement became a remedy that was recognized by the courts of England, for instance, the only way that once you get into a relationship with the other shareholders in these companies were, if you have a problem, to break up the company. So winding up was the only remedy that was once upon a time available. The law then realized or recognized that that was not the happiest situation to be in, that you could not continue a company if there was discord amongst shareholders. And then there was the evolution of oppression and mismanagement about which we are going to talk today. So the first thing that we were going to talk about are the circumstances in which shareholders can avail themselves of these remedies. Is that right, Nishant?
Yes, that's correct, Mr. Rodrigo.
So what we should now look at is that. So there are two limbs, broad limbs. One is oppression. So oppression is specific to the shareholder. That is the first thing that we need to know and understand. That is, if a shareholder is oppressed by actions that are being taken by the company, the management, in particular the board of directors usually, but also the majority shareholders or the shareholders who are in control, who create a situation or do acts that create an oppressive situation. So what is actually oppression is not defined in the statute, but broadly, I'm going to be rushing through this because of the time constraints, but we are looking at things like the denial of the shareholders' rights. That is usually the first thing. For instance, if there has been a dilution of the shareholders' shareholding by a bonus or rights issue, not a bonus, it would be a rights issue or a fresh issue of shares that are going to place him in a situation which is unfair or oppressive to his rights. That means he's no longer enjoying the shareholder power that he had before. Also, probity or fair dealing, that is, if there has been a matter that the directors of the company has done, which amounts to an abuse of power, where the shareholder is somehow being sidelined or his rights are not being given effect to, that would constitute oppression. Okay, so oppression is the first broad limb. It's usually coupled with the other, which is mismanagement, but we'll come back to that. So mismanagement is the section that is, or the mismanagement limb is the limb that is had most recourse to, for the reason that that is what most shareholders would complain about. That is to say, I am an investor, I'm a stakeholder in this company, and the company is being mismanaged. So obviously, if you have invested in something and there is bad management of that entity, you are going to have loss that is being caused to you because of the company not doing well. All right. So if something like that happens, mismanagement is the broad umbrella under which you would look at remedy or relief under. So again, there is no statutory definition, but mismanagement, you would appreciate, speaks for itself. A common example is where there is no proper arm's length transactions. Perhaps the directors or a bunch of shareholders are dealing with company assets or getting the company to get into transactions which are detrimental to the interests of the company. That would be a case of mismanagement, where the company is not being actually efficiently managed. That, though a shareholder may have a grouse, is not usually a basis on which a shareholder would go to court, because courts usually just don't get into the shoes of the board of directors to decide, can this company be managed better? What you're looking at is something worse than that, where there has been some bias or element of fair dealing that has not taken place. It is only then that mismanagement would take place. So two limbs under mismanagement. One is that the affairs of the company are being conducted in a manner prejudicial to the interests of the company. That means it's actually against the interests of the company that the company is being run in. So if properties are being sold to a third party or someone connected when the property should not be sold, or it's being sold at a cheaper price than it ought to be sold, that's instance of that. The other is where there is a material change that has taken place in the management or control of the company, by which reason you are expecting that there will be the company will be run in a manner prejudicial to its interests. All right. So that is, again, if there's been a takeover of control, for instance, and then the company is being run to the detriment of the company, but perhaps for the benefit of those shareholders, maybe they're having a competitive business. That sort of instance is where what that limb would cover. So to go into the, should I go into the next question now?
Yes, Mr. Rodrigo, just for clarity, now the jurisdiction to exclusively hear and determine actions relating to oppression and mismanagement with the Commercial High Court of Colombo. Would you say that the two most frequently used remedies in court with regard to minority shareholder protection are these two actions?
Yes. By far, they are the remedies that are most had recourse to. But at this point, I think it is useful to point out that there are two other sections that are used and ought to be perhaps used more. One is to do what is called restraining orders in terms of section 233 of the Companies Act. And that provides for correction or a restraint upon the directors where there is an apprehension that the company is about to engage in conduct which would contravene its articles or the act. So that the useful nature of the, or why it is useful, is because you don't have to have the qualifications of a 5% shareholding to institute those proceedings. You only need to be a shareholder. The other is the rectification of the share register. So that is again often had recourse to, and that is when there has been an omission in the share register where you're not put in at all, though you have paid money for shares, for instance, or the number of shares that your name is set against is not what it ought to be. So minority suits, yes, are the most they are the most used remedy, but these two are also quite common. And winding up is again a remedy that is used by some shareholders sometimes when the shareholders can't get on. That for shareholders to take that action is not that usual, but it does happen. Yeah.
Thank you, Mr. Rodrigo. Due to time constraints, let's move on to the next segment, that is with regard to derivative actions and whether they are not utilized enough in our courts. Just to give a brief background, the general principle in company law is that if a wrong is done to the company, then the only person who is entitled to remedy that wrong is also the company. However, the derivative action is an exceptional remedy which can be utilized by a shareholder to canvass the right vested in the company, where the company is prevented from instituting action to remedy a wrong done to the company. Mr. Rodrigo, can you tell us what are the exceptional situations in which a shareholder can use the derivative action?
Yes. So the derivative action really, as you quite rightly said, Mr. Sirimani, is an exception to the general rule that one party cannot sue and obtain relief on behalf of another person. So here is a situation where you can get into the shoes of the company and institute proceedings after obtaining leave and obtain redress or correct a wrong that is being done to the company. So the question that you were asking me is
the exceptional situations.
Yeah, the exceptional situation, when they can do it. I will just run through some of those now. The first thing is that you have to establish that the company has been wronged. You have to establish that there has been wrongdoing directors who are in control. And because of that, the company cannot file action or has not filed action on their behalf. Now, the problem here, and I'm going in perhaps into the next segment, is that the court must be satisfied that you are not what is called a busybody litigator. So the court must know that you are not just there to create a problem for the company or for somebody else, and you're using the company as a vehicle for that, that you're genuine. So that threshold, where's the qualification? Yes, the threshold of getting leave is what causes, you have asked me that question, so I'm getting into that now. The threshold of getting leave is what makes derivative actions not popular, because you have a two-stage process. One, you have to get the leave of court where court is satisfied, all right, Mr. Sirimana is entitled to sue X on behalf of the company in which Mr. Sirimana is a shareholder. All right. So you have to pass that threshold, and the court also looks at things like whether Mr. Sirimana is going to be successful on behalf of the company in winning that case. Then the costs of such proceeding, because a company is now going to go into court, file action, and that cost of doing so is going to be borne by the company. So you cannot allow all and sundry to come in and use the company as a vehicle. And then, of course, the best interests of the company are also paramount there. So it is only if court is satisfied with all of that. Okay, so the criteria that is set out is that the company or the subsidiary does not intend to diligently continue or defend the action, and it is in the interest of the company that such an action is brought up. So it's a cumbersome two-tier process, not had recourse to much, but it does have a place in our legislation. It has a place in commercial litigation or company litigation. But as I said, most people most counsel would advise their clients to try to do mismanagement. And particularly now that we have the section 233 and the section, the section 233 action available, derivative actions are not had much recourse to. Okay.
Thank you, Mr. Rodrigo. That explains why the derivative action remains underutilized in our court system. Moving on to the next segment, removal of appointment and removal of directors in companies are frequent sources of disputes and litigation. This next question is directed to Mr. Sadi Wadud. Mr. Wadud, how can a director be removed from a company? You have to unmute.
Mrs. Sirimana, first of all, thank you. And also the Bar Association. To answer your question, it's a fairly straightforward question. As you might be aware, the right to remove a director is one of the ultimate powers and control a shareholder has over a director. You actually really don't need any reasons for such removal. Can you hear me?
Yes, we can hear you.
It is enough for the appointer or shareholder to simply have a change of heart. He doesn't have to have any reason whatsoever. Therefore, generally, court will rarely interfere with a decision taken by a shareholder at a general meeting to remove a director. Now, Section 206 of the Companies Act has codified certain conditions as to how a director may be removed. Section 206 says, subject to what is stated in the articles, a director may be removed by ordinary resolution at a meeting called for the particular purpose. Therefore, first of all, a removal can be done by ordinary resolution, and it has to be at a meeting called for that specific purpose. However, this is subject to the Articles of Association. Therefore, one might have to look at the Articles of Association. As most companies today tend to follow the model articles, which is actually in the first schedule to the Act, I don't want to go through that. There may be several the procedures that may be laid down. Therefore, there is no inherent power a shareholder may have if the articles provide for a fixed period or for life appointment of a director in the Articles of Association. In addition to that, the articles, there may be other codes or rules and regulations of other statutory bodies also that might have a bearing on this. For instance, the CAC listing rules. Now you come back to the next section, that is 206 subsection 2. The notice of the meeting shall state the purpose for the meeting. And the purpose must be specifically stated as being for the removal of the director. However, the reasons for the removal need not be stated. Section 206, subsection 3 states, if the director concerned makes representations within 14 days, that copies of the representation should be shared amongst the shareholders. It is the duty of the company to share it among the shareholders. Normally, if a director who is sought to be removed wants to be difficult and wants to make scandalous remarks, sometimes there is a tendency to abuse this section, and therefore companies entrusted with the right to go to court in certain circumstances and obtain an order to refrain from sending the representations to the shareholders. Otherwise, the director may have the right to have the representations read at the meeting. Now, quite apart from these two sections, which is fairly straightforward, section 207 talks of vacation of post or vacation of office of a director by simply saying 207A, by resigning. Then when you are removed, 207, or removed from office in accordance with the provisions of the Act, or you become disqualified from being a director in terms of the provisions of the Act, or you die, or vacates office pursuant to section 210 subsection 2, or vacates office in terms of the articles. Now, this is an interesting area. One might have to go back and look at the articles. The specific grounds on which a director will vacate office are often made in the articles. These include continuous absence from meetings. It has been held in decided cases that mere absence from meetings or voluntary absence that is required. Mere absence from meeting is not sufficient, but voluntary absence what is required. If somebody, for instance, has been sick and has been unable to attend meetings, that will not qualify for the removal. Then there is a request to resign by all or majority of the co-directors or the appointer, or failure to meet share owning requirement, or where the articles provide for a rotation, or the failure to have an AGM can also result in the directors vacating office, unless there are provisions for automatic reappointment. Now, quite apart from this, there is another section which is relevant, which is section 208 of the Act, which talks of a situation where you are the only member in the board. So when you are the only member in the board, for instance, you are like the only member of the crew in a boat which is sailing, you cannot ditch the boat and abdicate your responsibilities. There are certain restrictions that are there. Then quite apart from that, there is an age of retirement specified in section 212, which is to send people home at the age of 70. These are the provisions that are relevant to the removal or to ceasing to hold office.
Thank you, Mr. Wadud. My next question is directed at Justice Masu. So what happens when a director is both an employee and a member of the board and he's removed?
Yes, thank you for the question, and thank you for the opportunity as well. I have to thank the organizers, BASL, and all those who have organized this for giving me this opportunity. Now, when you remove a director who's also an employee of the company, he wears two hats. So his one hat, the hat that he wears as director of the company, is not necessarily connected to the other position that he holds as an employee. There are two distinct kinds of office that he is holding. So when it comes to the removal, it's necessary for those who are contemplating the removal to consider very carefully the situation, because this can give rise to various complicated problems. An individual's role as an employee and role as statutory director are legally separate. This means that their removal from statutory office will need to be considered at the outset, as removing a director from employment does not remove them from their office as statutory director or automatically. remove him. So even if a person is removed as a director, he can still continue as a shareholder, or he can continue as an employee. So the whole situation has to be carefully examined when dealing with this kind of question. The provision for removal of a director from office is laid down, and as explained by Mr. Vadul, it involves giving him an opportunity for him to make representations against the removal. And in the same way, removing a person from employment, again, can give rise to issues involving labor law and also complex questions as procedure for that removal, to give him an opportunity to explain himself and also probably hold an inquiry. So these are two different situations. Now, it can be even much more complicated if this individual holds shares or share option. It can be very complicated. Dismissing an individual from their role as director and employee won't usually affect their position as shareholder or as a person who has a share option. And it is necessary, therefore, to examine the situation very carefully and deal with those two situations separately, having considered all these situations. And perhaps when it comes to removal of a person from directorship, it may necessarily be it's necessary for them to consider also the implications as removal of an employee.
Thank you, Justice Masuk. That was very clear and enlightening. Our next question will be with regard to directors' duties, responsibilities, and keeping directors in check. The 2007 Companies Act, for the first time, codified most of the duties that are imposed on directors and statutorily prescribed those duties. Mr. Wadud, you are, apart from a practicing lawyer in the field of commercial law, you also function as a director of several companies, including one listed company and several private companies. Now, can you tell us in a practical sense, since you have exposure to being a director in a company, as to what duties or responsibilities directors are most likely to default on?
Can you hear me?
Yes, yes.
Right. Yeah, Mr. Sirimana, thank you for that question. Before we come to the duties and responsibilities of a director most likely to be defaulted on, one might have to understand firstly as to what are the duties and responsibilities of a director. Now let's look at it from a laymanish point of view. As we all know, a company is a body corporate and it is a juristic person. It needs human beings to run the affairs of the company. Now the Companies Act number 7 of 2017, as well as the Articles of Association, would be the basic law which will govern the management of the company. The management of the company is entrusted to the board of directors. It is given in trust for the board of directors to manage the affairs of the company. Now, who are directors? Are they actually agents, employees, or trustees? As you know, in the past, there have been different approaches with regard to the functions of a director. However, when you look at section 529 of the Companies Act, which gives a very, very broad and wide definition as to who a director is, substantially looking at the functions performed by each within and in respect of the company. Now, what are their duties? Firstly, I would have thought the most paramount duty of a director is laid down in section 187, which imposes a duty on a director to act in good faith and in the interest of the company. Now, what is meant by good faith? Good faith is, according to my understanding, is acting honestly, with sincerity, without sincerity of intention, with no ulterior motives. Then It has to be in the interest of the company. Now, what is the interest of the company? Is it the personal interest of a director concerned, or the interest of a shareholder who nominated you, or the interest of a colleague in the board or the chairman, or interest of employees, or interest of some business associate or somebody else with whom you have some relationship? Now, actually, when you say you have to act in the interest of the company, actual interest of the company, the shareholders and all stakeholders of the company. When you say stakeholders of the company, it encompasses the entire gamut of the company, shareholders, directors, employees, associates, agents, business associates, all those people. Now, this duty of acting in good faith and in the interest of the company actually goes to the very root and purpose of the company for determining its success or failure. Now, this has been codified for the first time in section 187 of the Act. Now you come to section 188, which imposes a duty on a director to comply, to ensure to comply with the Companies Act and the Articles of Association. Now, does this mean for a moment that you only have an obligation to comply with the Companies Act and the Articles of Association? Obviously, no, because you have a duty in 187 to act in good faith and in the interest of the company, and subsequently you would see another duty of due care. So you have to comply with all laws of the country. If not, you wouldn't be acting in good faith. Having said that, there is a specific duty cast in section 188 to comply and respect the various provisions in the Companies Act and in the articles with regard to your duties. Because when you examine the Company Act in detail, you would find how a director and a principal officer at different stages become responsible for the conduct and affairs of the company. So that is why you need compliance of the Act. Now, the next most important duty is stipulated in section 189. That is a duty to exercise due care and skill. Now, this is a very interesting area. For the first time, this duty has been statutarized. You know, we have studied about the requirement of due care in law college and everywhere, but for the first time, Companies Act has imposed it as a duty on a director, which is a very onerous duty. Now, what is due care? Due care is to exercise adequate caution in all the circumstances of the case, because you are vested with the responsibility of taking board decisions in the boardroom and steering the company. In doing so, you have to exercise adequate caution in all the circumstances. Then the next thing is, what is skill? Skill is to use your expertise or knowledge or ability to your optimal benefit or to optimal benefit of the company to ensure that the company does well. Now, what is expected is not to act in a manner that is reckless or negligent. What is reckless and what is grossly negligent need not be given any explanation, because I'll give you a simple situation where you're put in a car, and if you're reckless and negligent in driving, you end up crashing and damaging the car, hurting yourself, hurting the other passengers, hurting the people on the street, and also perhaps causing damage to the public property. So that is, in analogy, I just gave that explanation, because the recklessness can bring in disastrous consequences to a company. We have seen in the recent past a trend in the collapse, particularly of finance companies. Now, we all know some time ago the collapse of the Golden Key debacle. Then in the recent times, we see the ETI crash. So it is of paramount importance to see and understand why these companies are failing. In my view, it's lack of exercise of due care and skill in the management that has resulted in this. For instance, one of the matters in the Golden Key debacle was that the regular licenses that had to be kept alive had not been kept alive. Now, taking a lesson from that, it might be useful today for directors who sit particularly in finance companies and banks and similar companies where there are regular licenses for renewal to take a legal audit on a regular basis every year. We are all very concerned and we take a financial audit every year. But I don't think we give so much of importance to a legal audit. But I know some smaller companies are doing it, particularly taking lessons from the golden key debacle. So that might be a way forward. Now, the next important responsibility, although it is not stipulated, is to be independent and very conscientious in your decision making. Because within the boardroom, you are making a decision for and on behalf of the shareholders and all the stakeholders of the company. So you can't have a lackadaisical attitude. You can't be a sleeping director by simply signing a document, and you cannot be heard to give an explanation. You simply relied on the skill and judgment of your friend who sat next to you, who is a specialist accountant or whatever. Likewise, when you're a lawyer sitting in the board of directors, as a lawyer, you expect a duty of care is very high. So you are supposed to blow the whistle and lead in matters where there is an important legal matter to be considered, and you cannot be failing in those duties. In those instances, particularly professionals, your duty of care would be even greater than others. Now, as a director, you are expected to exercise the due skill and judgment of yourself. So therefore, whatever the chairman or the other directors may have based on their thinking and experience, particularly if you are a professional, it is best that you independently and conscientiously exercise your own skill and judgment towards discharging this duty. Now, particularly as a director, consider a situation like the post-COVID pandemic. Now, we are all directors. How do you achieve the short-term, medium-term, and long-term aspirations of the company? Now, I know all of us are grappled with this problem, with the looming financial crisis and liquidity crisis. In order to offset the short-term liquidity crisis, we forget about our long-term aspirations and shut out or completely lay off staff. Sometimes, when you take such decisions, we have to exercise extreme care and due diligence and make sure that we are making the right decision, taking into consideration the short-term, medium-term, long-term aspirations of the company. Now, again, now having discussed these duties of a director generally, now the question you asked me was as to what are the duties directors mostly default on. In my view, the duty of good faith and interest of the company is also defaulted generally, but that has been happening for a long time. But the duty of due care and skill is the thing where we all slip generally. Because see, what has happened today is that sometimes we take on very much more than what we can chew. When you take the responsibility of sitting on a board, you also don't realize that together with that position comes a huge responsibility for you to go through all the material, documents, reports that are periodically submitted. You take on sometimes far too much, which is humanly possible for you to go through on a regular basis. Therefore, laziness sets in sometimes. There is a lack of interest for you to be very upbeat about your responsibilities. Then sometimes ego sets in, arrogance sets in. Therefore, for various reasons, corporate decisions are taken without duty of care. This is an area which generally, I think directors often fail. Now, it is a best practice. It is a good thing even for private companies now to practice good principles in corporate governance. Now, for instance, look at companies like Brandix and MAS. Although they are not listed companies, right? Their practice of good governance is exemplary. Even smaller companies should tend to take cue from that and follow that. Now, I come to another duty, which is laid down in section 190, is to, that is when you rely on advice by professionals, again, your duty to act in good faith comes into play. Then section 191 and 92 talks about disclosure requirements in company transactions, and then 200 talks of your disclosure interest with regard to share transactions. Then there is a duty not to disclose confidential information, section 197. But in listed companies, it might even be an offense. There would be charged for insider trading or insider dealing. So quite apart from this, there is also this duty when you reach 70, you put your hands up and keep the others informed. Quite apart from this, there is a serious duty on solvency of the company, which is stipulated in section 219. And with regard to serious loss of capital, I'm not going to touch on both these topics since I think in the number of questions that are going to be discussed, Dilshani is supposed to touch on that, so I leave it for her. Now, these are the primary duties that I would like to touch on. And is that it, Mrs. Sirimana?
Yes. Mr. Wadud, very briefly, due to time constraints, can you very briefly and quickly tell us, how do you keep delinquent directors in check?
Okay, directors in check. Okay, when you look at the Companies Act, there are several provisions in the Companies Act which makes the principal officers of the company and directors responsible criminally, and also their liability extends, there is civil liability as well. So then shareholder checks are there on delinquent directors, where shareholder on major transactions and on serious loss of capital, and the right to remove, that check is there. Then with regard to regulated companies, there can be regulatory imposed checks and balances if you are particularly listed in the Colombo Stock Exchange regarding arm's length transactions, related party transactions, etc. Then best practices in corporate governance that may be adopted by some private companies may impose upon itself certain checks and balances which a director might have to follow. Of course, regulated companies are compelled to follow the corporate governance codes. There are specific duties and directors requiring them to make disclosures in respect of transactions dealing in shares and in transactions which is of conflict of interest. This is a very, very serious, the conflicts register, where you have to disclose, you have to maintain a register for yourself and the company. That is a very serious check and balance. Then the periodic and regular audit of the company. More than anything else, I would have thought when you're a director, the biggest checks and balance that you have is within yourself, because you are supposed to act independently, honorably, and act within your conscience. That is the most important, although that is not law, that is expected. Then quickly to mention the checks and balances, there are several provisions. Civil liability, so many sections are there, section 17.3, 31.5, 41.4, 45. Likewise, criminal liability also, almost every section in the Companies Act make directors and principal officers criminally liable when they fail in their duties. So all these checks and balances are there, but when you are listed and a regulated company, there are further checks and balances imposed by the SEC rules or the Colombo listing rules, the Colombo Stock Exchange. I hope I have sufficiently answered your question, Ilshant.
Thank you very much, Mr. Wadud. Moving on to the next segment on the solvency test, stated capital and dividends. This question, the solvency test and the concept of stated capital were not found in the previous Companies Act of 1982. These were introduced for the first time by the 2007 Companies Act. My question is to Ms. Dilshani Wijewardena. Ms. Wijewardena, can you briefly tell us as to what these terms, solvency test and stated capital, mean and constitute?
Okay, thank you. Am I heard, by the way, Dilshani?
Yes, we can hear you.
Okay, good. Right. First of all, thank you for including me in this eminent panel. It's an absolute pleasure to be here. I think the question Ilshanti wanted is solvency test and stated capital.
Yes.
Let me start with solvency test. As you correctly said, yes, there was no such reference in the previous Act of 1982. It was brought in the 2007 Act. The purpose of bringing this solvency test is basically, I would sum, as the advisory commission summed up it in a line which said, it's like the golden thread that runs through the entire fabric of the Companies Act. So basically, it's a check to see whether you're healthy. Like a normal human being, you go to the doctor, you do the famous, the cholesterol, the blood pressure, the famous test to see whether you're physically healthy. So this is a test which you do to ascertain whether you're financially healthy. And moment you there's a red flag in the solvency test, that means it is an indicator that you're financially either bleeding or there is some sort of a problem within you. You have to fix it. Just a little background in the 1982 Act and the previously, what actually protected a company, the capital, was the common law principles of capital maintenance. You must understand, capital of a company is actually not for the benefit of the shareholders. It is for the benefit of the creditors. So you have to look after this kitty, so to speak, for another segment of the company. Now, this maintenance of capital principles, or the doctrines or the jurisprudence of maintaining of capital, has almost been transferred to this new concept called solvency test, which you see in section 57 of the Act. So if I briefly say, it's a very technical definition. Solvency test has, I think, under 57, 2 limbs. It's called the liquidity limb. That is what we call your ability to pay debts as and when it's due. Now, what do you mean by ability to pay debts as and when it's due? I think if you look at section 271, it is basically to say, as and when the bills come, you should be able to pay. The next is the balance sheet test. These are very accountants sort of playground, so I'm not going to delve into that. It's basically to say your value of your assets should be greater than your liabilities and stated capital. So what is, for me, what is more interested in the stated capital is not the formula by which you, solvency test is not the formula by which you decide whether you're solvent or not, but actually 57 subsection 2, which says that in determining whether a company satisfies the solvency test, there has to be due regard to the latest financials of a company. Then the directors must personally know or ought to know what is going on in the company. At the end of the day, solvency test is not just putting numbers in a formula and said, you know what, we are solvent. It's not that. The persons or the board should be privy to a lot of inside information to really and truly know whether you are solvent or not. So in the rubric of all that, that is the solvency test, which runs throughout. If you look at the entire gamut of the sections, it is like a red flag to say, okay, before you do something, see whether you're solvent. Before you make a decision, see whether you're solvent. Before you declare dividend, see that you're solvent. So that is, in sum and substance, the solvency test. The next thing is, I think the question is stated capital. Is that, am I correct? Yes. That is also a new concept that came in the 2007 Act, replacing the old concept. I think if you, the old lawyers could remember, we had those authorized capital, we had the issued capital. So basically, all that was done away with. We came up with this concept called stated capital, again, another accountant's terrain, which basically means all the money or the amounts that is received or receivable by the company is called stated capital. And another interesting departure in the new 2007 Act, I wouldn't call it even new, now it's 2007, is pretty old, is the value that is attributed to the share. Those days, it is, we all remember the par value and the magical 10 rupee par value. Today, consideration is fixed by the board of directors, because they themselves will look at the real marketability of the share, look at the balance sheets and see how much a share is worth. Now you can see now certain companies are trading around 30 cents, 15 cents. So that reflects the true value of the value of a share. Yes, so if, and also just a quick departure of when you come to stated capital. So at the end of the day, as I said, the doctrine is to preserve the capital for the benefit of creditors. board of directors nor shareholders can willy-nilly kind of distribute this for their benefit. That is why you have stringent requirements. If you have to reduce the stated capital, I think section 59, there's a whole load of procedure that you have to follow. This is, if you look at very jurisprudentially, stated capital is a capital that is fixed in the company for the benefit of your creditors, and all the common law doctrine, all the jurisprudence for the maintenance of capital will be applicable to maintain the stated capital of the company. Nilshanta, do I answer those two questions? Stated solvency and stated capital, that's all?
Yes, that's it.
Okay.
Thank you, Dilshana. We'll move on to our next segment, which is the duties of directors at times of insolvency and serious loss of capital. Now, this question is also directed to Ms. Dilshani Wijayawardena. You are the author of the book Company Law, which is one of the most comprehensive works available today on Sri Lankan company law. You are also a director of Union Bank PLC as an independent non-executive director, which is a listed company and a licensed commercial bank. Now, the economic impact of COVID-19 is apparent in many countries across the world, and Sri Lanka is no exception. Companies are running into severe financial difficulties as a result of the pandemic persisting. Now, in this background, can you enlighten us, Ms. Wijayawardena, on the nature of the duties imposed by the Companies Act on a director at a time of insolvency?
Okay. Yes, as you said, Nilshanta, COVID has thrown in a lot of uncertainties in the financial world. It is unprecedented times, and companies are running very low on their financial stability. I mean, it's no secret. Tourism sector, lots of sectors like that is severely impacted. So one has to, if you are on a board, one has to know the duties when you are running low on steam, so to speak. And that is reflected. Let me take one section at a time. Section 219 is a duty of director in a case of insolvency. Now, that begs the question: what do you mean insolvent? In a generic way, it means that you are unable to pay your debts as and when it is due. So then the $1 million question is: okay, now you have come to this situation where you cannot pay your debts as and when it's due. So what is your responsibility vis-a-vis a director in such situation? I think 219 is pretty self-explanatory, but in general terms, moment you are aware that you cannot pay your bills, the first person who gets aware of that is your board of directors. You will know when the bills come, you cannot pay. So there is a duty cast on a director. When you cannot pay, the first duty is that you have to, under 219, is to, let me see, it says, where a director referred to fails to come, let me see, okay. Director of a company who believes that the company is unable to pay debts as they fall due shall forthwith call a meeting to the board of directors, whether the board shall apply to the court for a winding up of the company and appoint a liquidator or appoint an administrator. So immediately, moment you get to know that there is a the bleeding, or you're unable to pay the debts as and when you fall due, a director is under obligation under section 219 to inform the board, and the board as a whole must sit and decide what actions you have to take. That is section 219. Now, if you ask me, because if certain companies, especially with regard to banking sector, there are 3 regulators in this country. You have the banks being regulated by the central banks, the finance companies regulated by the central bank. Then you have all the listed companies regulated by the CSC and the SEC, and you have the insurance companies regulated by the insurance board. So these authorities can, over and above this requirement, impose more stringent requirement. Now, for example, recently moment when the pandemic hit, central bank issued a directive to all banks saying till I think December 2019, you can't pay dividend. You can't pay bonuses. So you freeze the kitty, so to speak, so that there is no bleeding, there is no hemorrhaging of the funds of the company. So that is section 219. Yes, and then if I can move on to
serious loss of capital.
Yes, serious loss of capital. Again, I just said what is meant by stated capital in my previous question. So the stated capital is the fund that you maintain for the benefit of the creditors. It is the substratum of your company. So it's extremely important that is preserved. Now, as I said, coming back into a more regulated companies, be it, say, for example, banks, since I'm a director in one of those, I know for a fact that capital is sacrosanct for the maintaining or the continuing of the bank. So you have capital under the BASL requirements. You must have X amount of capital untouched. That is your capital requirement for the carrying of the banking business. So under 220, if there is a hemorrhaging of a capital or the capital is coming down, there is duty cast on directors to call an immediate EGM to the shareholders. And then at that EGM, you're supposed to propose a sort of a document, a report saying, what is the problem that is causing these issues? What are the steps that you're going to take to fix this? It's like thinking of, look at like a ship that is leaking. So you have to decide where it's leaking, how you're supposed to plug it. So, and if you don't take these actions, please remember, I think I forgot to say it in 219 and 220, both are sections which has a liability, statutory liability cast on directors for not taking the relevant steps that is required. For example, in 219, calling a meeting, and 220, calling an EGM and discussing it with the shareholders. You can be criminally liable, if I'm not mistaken. 220 subsection 4 says, when the board of a company fails to comply with subsection 1, every director and those who knowingly participated shall be guilty of an offense. So it's a criminal liability. You have been put up at that threshold of absolute criminal liability because you are hemorrhaging a company of its substrata. So that is 220. And as I said, 219 is on duty on insolvency. And we must not forget companies that are regulated over and above the Companies Act, like under the central bank, the Colombo Stock Exchange, or the insurance board will have another set of checks and balances a company has to comply with. So yeah, that seems to be it.
Thank you, Dilshani. Moving on to our next segment about the Articles of Association of a company. The Articles of Association is considered the constitution of the company. The contractual rights and relationships as between the members and the company and as between the members themselves are governed mainly by the Articles of Association. So my next question is to Justice Masuf. If a particular situation is not covered by the Articles of Association, what is the next step, or what is the next resort, Justice Masuf?
Question is ambiguous to some extent, so I will have to say this.
Yes, if I may clarify, if there is a conflict between the Articles of Association and the Companies Act, for example,
yeah,
what would the company have to rely on in a situation of a conflict?
Yeah, I think the provisions of the articles are important and provisions of the Companies Act equally important. And when one look at it, it seems that they work together. But when the articles are inconsistent with the provisions of the Companies Act, then we have a situation where the articles have to be applied in any event because the articles override.
Yes. Thank you, Justice Masuf. My next question on the same topic is directed to Ms. Vijayawardena. Do you feel that there is insufficient reliance placed on the articles to resolve internal disputes in a company?
Rishant, we go back to the concept of articles is the constitution. It is your go-to document in a case of knowing what to do. First and foremost, a company is governed by two sets of laws. First is your, not two sets of laws, I would say two principal documents. One is your Companies Act, next is your articles. So the articles is for the internal controls, provided that nothing in the articles is inconsistent with the Companies Act. So it has to be harmoniously read with the Companies Act. So you can say anything beyond it, provided it does not violate the jurisprudence or the legal standards embedded in the Companies Act. Having said that, one of the things from my experience I have noticed is, moment there's a problem in the company, lot many people go and refer to their articles. All the answers are in that. They would probably run to the lawyer, probably will complicate the situation. First recourse, if you have an issue, whether it be how do you enter into a contract? Should I put the seal? Should the two directors or one director or three directors should sign it? Should say signing powers? Who has signing powers? How do directors are appointed? How do, when they resign, what is the next step that has to take place? Secretaries, dividends. I mean, the whole gamut is in the articles. So the first port of call, in a situation where you are contemplating, can I do this? Is it right if I do that? Is your first port of call is your articles of association. See that, go through that. And if there is sort of a lacuna in it, then you can refer to the Companies Act and see what is in the Companies Act. At the end of the day, that is the law of the land, your Companies Act. This is not only for the internal control, but I see sometimes I can see even in certain situations, for example, certain banks, when they give loan, they want certain things entrenched in the articles so that they have a right, because at the end of the day, you are circumscribed by the four corners of the articles. You can't do anything less or you can't do anything more. That is the boundary. So if you are some certain banks, when they want to give a loan, they say, okay, we shall do so if you put these clauses into the articles. If you are a dispute with the bank, refer to those articles. Sometimes you have shareholder agreements. Sometimes shareholders get together. Sometimes major shareholders get together and say, okay, let's vote in this way for such situation, or let's do this particular way. Well, it is not binding on the company unless it is entrenched in the article. So if you are a shareholder and want to get into a shareholder contract, first advice if I would tell them is, okay, pointless having shareholder agreements. It is not worth the paper it's printed on. Only thing you can have is you can sue each other for breach of contract. But if you want the company to be a party to it, entrench it in the articles. So my advice simplicity is, if there is an issue, first and foremost, know your articles. Go to it, read it, know it inside out. If there is some sort of a gray area, you can always refer that in the Companies Act.
Thank you, Dilshani, for providing clarity on that question. Let's go on to our next segment. This is directed to Mr. Arvind Rodrigo, PC. So are there any significant recent developments in company law litigation or in judicial decisions?
Yes. Yes. Yeah, let me just respond to that. But before that, I think I want to register my protest that Dilshani just called some of us old lawyers, and that is coming on the back of Tanya calling us mavericks. But we do remember the 82 Act, anyway, that's the labeling that we have to run through these days, I guess. So to get to the question, the recent developments, some interesting developments. One was where there was mixing of a minority suit with a derivative action. All right, so this is unprecedented in Sri Lanka. There have been some decisions overseas where that had happened. Personally, I don't think it is good law, but it appears to have been followed, I think, in Canada and maybe in England also, exceptionally. So you have a mixing of these two different types of suit, and there seems to be a contradiction there, because one is talking about a wrong done to a company, where you get into the shoes of the company, and the company you're suing for and on behalf of. The other is obviously where the shareholders' rights themselves are affected. But anyhow, there was a case that was launched like that. We call it the Macwoods case because that was the subject matter. There's a decision on it, I can talk about it. And the judge held no, that the Commercial High Court held that we cannot mix those two. The other, this is not very new, but something that has kept cropping up is, and Dishani talked about, where the articles of a company provide for resolution of disputes. And here we had a situation where the articles had provided a dispute resolution mechanism outside of courts, namely arbitration, all right? So what happens when you have the articles of the company to which all the shareholders are party, all have agreed, deciding that their disputes should be resolved by arbitration. And I still remember appearing before Sarat Silva there and objecting to court exercising jurisdiction under the Companies Act, because obviously that was another remedy. And in the Garment Services Group, that case, it was Justice Sarat Silva held, his lordship, Justice Sarat Silva, who was Chief Justice at that time, held that the Companies Act remedy is statutorily provided, and therefore, even despite all of the shareholders having agreed that disputes between them and the company would go to arbitration, the remedy given under the Companies Act still would be intact. Now, another more recent development is where a case where a Companies Act application or an application that should have gone to arbitration was dressed up as a Companies Act application, all right? So you have a dispute between shareholders which doesn't fall within the category of oppression and mismanagement. Okay, it's a dispute between shareholders inter se. It's not really to do with oppression and mismanagement. It's to do with, for instance, an obligation of one shareholder to buy another shareholding at a particular time, maybe an option, something like that. So when something like that happens, or when that's what's provided for to go to arbitration in a joint venture agreement or articles or anything like that, what happens if somebody dresses up that dispute to become a minority suit or an oppression suit? And there, the case was Subramaniam and Mascons, decided in 2018 in the Commercial High Court. Sadly, we don't have Supreme Court decisions on these. Justice Juan Fernando, in a very erudite judgment there, I say, worked out that dressing up does not change the nature of the dispute, all right? And this is something that comes up. So I don't want to go to arbitration, I want to go to the court, so I dress it up one way or the other. So those are two significant developments where you have the mixing of the different remedies. The third one is where, on a procedural issue, which people might find interesting or important, is where you know that even under the 82 Act, which us old lawyers still remember, there was provision that it was virtually that it was summary proceeding, petition, affidavits. Similar provisions are there now. But Justice Shirani Tilakavadana held that you can actually lead evidence, okay? So that was a winding up application, but the same by analogy, or you can apply that to mismanagement suits or any application to the court under the Companies Act, that you can have actual evidence, that is a set issues to be raised and all of that, where there is a huge divergence on the facts. So it's not good for all cases, obviously, because you need expeditious disposal and company matters can be dealt with on the paper that is before court, but sometimes you can go into a trial, and I think it's a good exception that was established. So those are the three developments I think that we can talk about that has happened in our commercial high courts recently.
Thank you, Mr. Rodrigo, for those useful recent developments in company law, which we rarely come across. The next important segment is on corporate governance. Now, my first question will be directed at Justice Masuf. Justice Masuf, corporate governance is a very hip and fashionable term that is used by most people now. But do we actually know what it means and entails? So in that light, can you explain, Justice Masuf, as to what corporate governance actually means in relation to companies?
Well, thank you for that question. Corporate governance in the business context, because all the companies are doing business. So in the business context, it refers to the system of rules, practices, and processes by which companies are governed. Now, funnily, in the Companies Act, you don't find the word governance at all. And you find the word corporate everywhere and incorporated, etc. But you don't find the word governance. But there are embodied in the Companies Act many provisions which in fact provide for corporate governance without using that term. And so may I simply quote in this instance from OECD, which is the Organization for Economic Cooperation and Development, which has referred to corporate governance is a way in which the two main stakeholders, that is the directors, the managers of the company, and the shareholders, how they resolve their conflicts and disputes in a manner in which that will not harm the company, but it will add to the versatility of the company. So OECD says that it is, for the purpose of corporate governance, is to help build an environment of trust, transparency, and accountability necessary for fostering long-term investment, financial stability, and business integrity, thereby supporting stronger growth and more inclusive societies. So what I really would try to do here is to first say that although there is no express reference to corporate governance, there had been an endeavor on the part of the Sri Lanka Institute of Chartered Accountants and the Securities and Exchange Commission from a fairly long time, where they have developed what is known as, what really is known as a code. It's a code of best practices, which has been revised, I think, for the 5th time in 2017, and which can be seen online. But basically, I would like to refer to a few provisions of that, which will explain how it is and what it happens. But before that, I like to refer to the concept of trusteeship. All the directors, they hold what is known as a trusteeship to safeguard the interests, the properties, the investment of the shareholders. And in regard to that, in the code of which has been prepared in 2017, but which is only the 5th edition. It has been, I think in 1997, they started doing this. In A15, it is said that all directors should bring independent judgment to bear in discharging their duties and responsibilities on matters relating to the board, including strategy, performance, resource allocation, risk management, compliance, and standards of business conduct. So in other words, there is an imperative duty put on the directors to bring in their independent judgment, which, as Mr. Wadud has been trying to explain, is without conflict of interest. You get over the conflict of interest by proper procedure and transparency. And then I also like to refer to A51, which says that the board should include non-executive directors of sufficient caliber and number for their views to carry significant weight in the board decisions. In other words, I think one of the reasons which we have had so many crashes of companies is because the independent directors did not function effectively, and also in some boards of directors, they didn't have independent directors at one time. So now this code of conduct refers to the duty to include non-executive directors of sufficient caliber and number of for their views to carry significant weight in the board decisions, and the board should include at least 3 non-executive directors or such number of non-executive directors equivalent to 1/3 of the total number of directors, whichever is higher. In the event the chairman and CEO is the same person, or if the chairman is not an independent director, non-executive directors should comprise a majority of the board. That is one way in which it is sought to bring about greater governance and independent judgment, which has to be exercised without bias and without conflict of interest. And then I also simply wish to refer to A52, which says that where the constitution of the board of directors includes only 3 non-executive directors, all 3 non-executive directors should be independent. In all other instances, 3 or 2/3 of non-executive directors appointed to the board of directors, whichever is higher, should be independent.
All done.
And it is also stated in A53 for a director to be deemed independent. Now that is very important, because we have to understand the concept of independence, and that is laid down in A53 of the code, which says that for director to be deemed independent, such director should be independent of management and free of any business or other relationship that could materially interfere with or could reasonably be perceived to materially interfere with the exercise of their unfettered and independent judgment. So I think any board is in a state of tug of war very often, because there are companies where there is fair amount of harmony, but in most instances there can be conflicts between the shareholders or shareholders and directors, etc. And so it is necessary to bring about better governance. And there is one other aspect of corporate governance which I wish to refer to, and that is the duty of the company towards society, and which we call social responsibility. And most of the companies which do business, not only in Sri Lanka but even in other countries, they don't care very much for the impacts that they are having on the environment and many other aspects of, including war and harm that is done by even nuclear war. And for those reasons, it is necessary also to emphasize the social responsibility of, which is a new thing that many is evolving, but that is important for the purpose of good governance and corporate governance.
Thank you, sir. Very quickly, unfortunately, we will have to end the session on corporate governance. Just one final question on corporate governance, which I would like to direct to Ms. Dilshani Wijewardena. Ms. Wijewardena, is it mandatory for all listed companies in Sri Lanka to have or adhere to a code of governance?
Yes. Corporate governance is a kind of a set of rules, I would say, which is over and above the law. If you look at briefly the history from the 2008 financial crisis to 2000, when the big guys in the United States like Enron's, Debacle, you have Tyco, all those companies crashed. They realized just following the law did not ensure that the company carries on. And there is so many ways you can walk, let me say, outside the law. So hence this concept called corporate governance was born. Now, Justice Masuf did mention the jurisprudence of corporate governance, but if I have to go a little one step beyond that, if you are a PLC listed on the Colombo Stock Exchange, you have corporate governance mandatorily to follow. It is not something you can say, well, I do not want to follow. It's basically in Sri Lanka, it's either you comply or you explain. That means you have to comply. If not, you must set in your report to the Colombo Stock Exchange why you can't follow that. So there is a set of listing requirements. If anybody is interested in further educating themselves, please go to the Colombo Stock Exchange website, type in listing rules, and you will have, I think, section 7 with a whole host of corporate governance provisions there, where all PLCs listed on the stock exchange has to follow. Just a brief note on that. If you don't follow the corporate governance rules of the CSC, you will be put to the watch list. That is, first of all, you'll be given a warning. And if you still don't follow, your trading of shares will be suspended. And if you still don't follow, you will be delisted. That is with regard to the listed PLCs. A quick thing about, I said at the beginning, there are so many regulators. If you look at the central bank that regulates banks and all financial institutions, not financial institutions, sorry, finance companies, Banking Act number 11 of 2007 has a whole lot. If anybody is, again, more interested, please go to the central bank website, type in corporate governance for banks. You will have a whole series of it, which in this case, you have to comply. And even what I like about the central bank corporate governance rules is that even those who are to be or ought to be a director is absolutely spelled out with such clarity. It goes beyond the Colombos. I normally call it the boys club, because who is the directors are all this, I know this one, I know that one. So it goes against that. You have a very stringent fit and propriety set of rules which govern who can be appointed to a board of a bank, because at the end of the day, you must understand you're looking at maintaining or looking after public money. So you can't have just the friendships coming into a banking sector. So even not only are you supposed to follow corporate governance, as to the appointment of directors, there's stringent procedure as to fit and propriety. All your past records, your bank accounts, everything comes into play when you have to be appointed a director at a bank. I think I'm running out of time. I would love to elucidate, but since there is no time, that seems to be that. I'll wrap it up.
Thank you, Dilshani. That basically concludes our panel discussion on the various issues that we raised. Now let's quickly move on to the question and answer session, where several questions have come in from viewers. I'd like the panel members to keep their answers as brief as possible so that we can take in as many questions from our viewers. The first question I'd like to, from a viewer, I'd like to refer to Mr. Avinder Rodrigo PC. The viewer wants to know whether a judgment obtained against a company, can be executed against its director in the event the company does not exist but has not been struck off the register.
Yeah. Am I not muted now? Can you hear me?
Yes, can hear you.
So short, the question was that, can a judgment obtained, I'm presuming this is a judgment in a normal civil suit that is obtained against a company, whether that can be executed against a director?
It's the other way around, Mr. Rodrigo. Whether a judgment obtained against a director can be enforced against the company, executed against the director in the event the company does not exist.
So a judgment against a company cannot be...
Yes.
Yeah, a judgment against a company cannot be executed against a director. The reason in a normal civil judgment that has been obtained, for the reason that obviously their corporate veil and so on, directors are not personally liable for the debts of a company or a judgment debt of a company. The exception is obvious, of course, when there is some statutory liabilities imposed on a company such as when going to the areas of taxation or industrial disputes, EPF, ETF, and so on, where directors become liable. But in a normal civil suit, if two corporates or an individual sues a company for money, not a tax matter or a labor matter, no, you cannot.
Okay. The next question is it
sorry,
in order?
Perhaps I should finish that, because they said if the company doesn't exist, what you
Yes,
can
but
do,
has not been struck off. Yes.
Yeah, and if the company has not been struck off, that means the company is in existence. That means you can go after the directors to disclose the assets of the company and so on. You can make an application for oral evidence to be given by the company of the directors of where those assets are. And if a liquidator has been appointed, of course, you can chase after the director for that money. Yeah.
Okay. Thank you, Mr. Rodrigo. The next question is open to any one of the panel members. Is it in order for the shareholders of a private limited liability company to propose and second a name for a directorship directly at the AGM without going through the board of directors?
The question seems to be not that clear. If I can answer that, what does it? Can you propose a name?
Yes.
Of a director without going through the AGM? Is that?
That's correct. Whether you can propose it directly at the AGM without going through the board.
Technically, the law is the shareholders appoint directors. However, the board has to function as a board of directors, and the normal procedure is you propose a name and you suggest a name, and the shareholders authorize or vote in favor of it. Because you shareholders cannot just willy-nilly put people onto a board, because at the end of the day, the board of directors, there has to be synergy in their directions, and probably in a company like a private company, I suppose, since the numbers are very small, I suppose it can be done, because you're looking at maybe they're family companies, they're smaller companies, but definitely in a PLC, no.
Okay, thank you, dear Shani. The next question, would there be a possibility of using oppression or mismanagement remedies where the minority stakeholders, especially significant minority stakeholders, hold the majority of shareholders to ransom or do not let them carry on business of the company? I'd like to direct this to Mr. Rodrigo. Is the question clear, Mr. Rodrigo, or can I repeat that?
I think I got it. I think the question is where you have a significant minority shareholder.
Yes.
And this minority shareholder is holding the majority to ransom. That is, the minority, the tail is wagging the dog, so to speak.
That is so.
When that happens, the provisions of our law, which is modeled on the British, obviously, allow for control, allow for action in the instance of there being control vested in anyone. All right. Okay. So if there is a board that doesn't even have shares or has very few shares that is controlling the company, still a minority shareholder or even the majority shareholder can go to court on that basis. So what is material is whether or not the control lies with the party that is doing the wrongdoing. Okay. So even a minority shareholder who's controlling the company and is doing wrong, he can be brought to book or brought to check by a litigant who has the majority, in fact, but is not in control. Yeah.
Okay. And the next question is also to Mr. Rodrigo. It arises from a reference you made earlier to a case. The viewer wants to know what is the name of the action mixing up the actions. I believe the viewer is referring to where you mentioned a derivative action and minority oppression or mismanagement action being mixed together.
Yeah. So that is, yes, the case number, I will just tell you now. Hold on. It's 35 of 2016 CO. The company that was the subject matter of the dispute was MacWoods PLC, and the order is on the 18th of November 2016, and it was by Justice Mr. Shiran Gunaratna at that time, High Court Judge, His Honor, who's now in the Superior Courts. On this, and actually, I don't know whether what the protocol is. I have some notes on this, which I'm happy to share with anybody who asks for it.
Okay.
Yeah, which we can.
Thank you, Mr. Rodrigo. The next question is for Ms. Dilshani Wijayawardena. The viewer wants to know whether should you go to the Act only if there is a lacuna in the articles?
Well, articles and the Act must be read together with a synergy. Everything is not included in the articles. Day-to-day running of the company is included in the articles. So if you have an issue, please, the first port of call is always the articles. If it is not explanatory, then refer to the Companies Act. But as I said earlier, both must be read together. There is a synergy between these two.
Yeah. Can I just also add there something that is different in this new Act, which I can remember as an old lawyer comparing to the 1982 Act, is that this Act provides for when the Act will prevail and when the articles will prevail. It says notwithstanding anything in the articles in many provisions, and in some provisions they say subject to what the articles say. So that means that you don't have to always decide that the Act prevails or that the articles prevail. The statute provides for when that would happen, either way.
Okay, thank you. The next question is also directed at Mr. Avindra Rodrigo. Mr. Rodrigo, do you feel that if proper corporate governance measures were adhered to in companies like Golden Key, Selinco Shriram, CIFL, and Pramukha Bank, the collapse of those companies could have been avoided?
Yes, the short answer is yes. Corporate governance internally, and of course, there has to be better oversight by the regulators because these were companies that are accepting public shareholders, public monies. But certainly, if there was corporate governance followed, and if the corporate governance, which is yet not mandatory, is brought into force and given effect to, certainly this would avoid the debacles that we had in the recent past on those. Yes.
Okay. Thank you. I think we've overstepped time constraints. So we'll have to end the session there. Before we go, I'd like to thank the BASL for organizing this webinar. And I'd like to thank our distinguished panel members, Justice Salim Masuf, Mr. Avindra Rodrigo PC, Mr. Sadi Wadud, and Ms. Dilshani Wijayawardena for their expert comments and very enlightening discussions that we've had during this session. My thanks also go out to Ms. Tanya Gunawardena for initially hosting this session, and to the Secretary of the BSL and the Assistant Secretary of the BSL and the technical staff of the BSL who made this webinar a possibility. So thank you all, and thank you to all the listeners who, the viewers who logged in and participated in this webinar. I'm sorry that we couldn't take all your questions because we overshot the time limits. My apologies to all those who post questions. We will try to answer those questions privately. And any case law that Mr. Rodrigo referred to will also be provided if your details can be made available.
I also have a note if anybody wants. Yeah.
Yes, and also a note prepared by Mr. Rodrigo.
Yeah.
So
Can I just say thank you to Nilshant on behalf of all of the panel for keeping us.
Yes, thank you so much for a job well done.
To the rest of the panelists, it was a pleasure. And
it was a pleasure. Yes, thank you all.
Thank you, everybody.
Thank you,
Okay, good
Nishant.
night.
Thank you.
Okay,
Okay, good night.